afternoon, everyone. I am Carol Morgan. I'm at the University of Georgia School of Law. I head up our Business Law and Ethics program there, and I'm joined today by two very distinguished panelists, Tamar Frankel, who's from Boston University, and Robert Rhee from the University of Maryland. You'll hear a lot more about them and what they're up to in just a few minutes. And I'm glad to see this interest in business ethics, or the topic of business ethics. Law schools have historically not paid a lot of attention or focused a lot on the subject of business ethics. We've done a pretty good job, I think, of talking about the law and professional ethics, but there are not a lot of courses out there that I can find in my unofficial survey of law schools on the internet that focus on business ethics. And so what we're here today is to try to brainstorm ways that we can do more incorporating of the topic of business ethics into our law school curriculum. MBA programs, on the other hand, have heightened their focus on business ethics in light of all the scandals of this century. They have been very interested in more courses, more professors, and even taking oaths. At Harvard, they take the MBA oath, or a number of students have taken that, where they pledge that they will act responsibly, ethically, and serve the greater good. Students at Columbia Business School sign a pledge that they will not lie, steal, or cheat, and won't tolerate other people who do that. So in light of the changing climate in our business school education, it seems to me, since law students will have business clients in the future, that it's important for our students to understand the ethical issues and complexities that business clients face, and to figure out ways that they can help more effectively represent these business clients. So that's why I have had a particular interest in business ethics. Also, my background is as a practitioner. I was an in-house counsel and general counsel at National Service Industries here in Atlanta for 25 years, and my experience was that my business client wanted me to provide some guidance beyond just the law. And it is true that a lawyer can represent a client very effectively or very competently if they expound on the law, they do it within their professional ethics, and put a period at the end of the sentence. But I suggest that maybe some of the crises that we've seen might not have happened if the lawyer had talked beyond that period at the end of the sentence and had discussed some of the ethical implications that are involved. And I know, based on my experience, the business client welcome those discussions because they look at lawyers as wise people who can see a big picture. And so I think that discussion needs to take place more because law students are not prepared for that discussion. And that law schools have a role in preparing our students to talk more than just the law, which is a more limited approach to counseling. Obviously, the client's the ultimate decision maker, and a lawyer has to recognize that there are limitations there. But I just think that discussion needs to take place. So how can we do this in a law school? How can we bring up this issue of business ethics? And there are different approaches, and those of us on the panel today represent different approaches, and there are probably others. And I'm curious how many of you have business ethics courses in your curriculum currently.
Help me if you gave me some guidance about what you mean.
What business ethics?
Well, it would be helpful if you distinguish between that element of ethical responsibilities that apply uniquely to business. Then I'd be able to tell what it is we do.
Okay. Well, I think it encompasses a number of different things. There are obviously there's a compliance component to ethical behavior. But beyond that, there is also kind of the corporate responsibility, social responsibility issues that are part of ethical issues, just understanding the implications of conduct. in a community setting or in a corporate environment. There's sort of that, it's the right thing to do. There are companies that in their code of conduct, we do the right thing. Well, what is that right thing? And companies define that differently. But I think it's more, to me, it's more than just compliance issues. Though that is certainly a component of it. Compliance with the law is sort of a minimum standard for me. And are there other implications that we need to examine to see what impacts there may be on other constituencies, on communities, on employees, on customers, on vendors, a broader approach. But really it's looking at impacts of conduct. And trust and honesty, which is the name of Tamar's book, and the teachers, or the case study that Mark, and I didn't introduce Mark Bagan, but Mark Bagan also co-authored with Tamar, those are the issues, the trust and honesty issues that companies face. Does that help at all?
To start.
A little bit. I think we'll get more into that as we get through this. It's a lot easier, as I say, where there are rules. To me, when you get into the area of corporate conduct that goes beyond where there are no really rules written down, and you're dealing with issues that are much more complicated. It's easy when you've got rules and compliance issues. It's much more difficult when you're dealing with things that involve more than rules and looking at impacts. But we definitely will examine all of that. But I saw a couple hands at least where there was actually something along the line of this of corporate ethics, corporate conduct.
We have a course called Business Ethics.
Business ethics. And where are you?
Philadelphia.
Okay. And where was the other one? There was another hand, another business ethics course. Okay, there's one approach is the standalone approach, the standalone course approach, and that's what Robert at the University of Maryland teaches a course basically that looks at business ethics from an economic theory approach coupled with practical application, and he'll expound more on that. What I've done at the University of Georgia is a more integrated approach where I incorporate it into existing courses on transactional skills. And we have a lot of discussion about ethical situations that their clients will face and what the lawyer's role may be in helping the client think through the issues. And then another approach is what I call the collaborative or interdisciplinary approach, which Tamar and Mark is with the Kennedy School at Harvard, and they have been working on a course that would ideally involve both law students and business students in the discussion and figuring out ways of examining case studies, actual case studies of corporate conduct. So, and I'm interested in if you all have other approaches in your courses, that would be very helpful to all of us, I think. But I think we're going to start with Robert, who's going to talk about the standalone course approach, and sounds like what you may have at Villanova, and go from there.
Thank you, Carol. Hi, good afternoon. I'm Robert Rhee at the University of Maryland, and the subject of my discussion is teaching corporate ethics and social responsibility. I teach two courses, one at the law school and another one at the business school. And so the law school is a seminar with research paper, satisfies the advanced writing requirement. That's about 10 to 15 students. The business school course, I just finished that. It's part of the core business school curriculum. And the law school, we have some joint JD MBA students. So for the JD, for students in that program, they can take one or the other and satisfy both programs. And the students are about 30 to 35. I found that both courses are switch hit, and that I really haven't changed a whole lot in the syllabus from one to the other. And the courses do fairly well, it seems. At least the evaluations seem to be pretty good. I haven't received my business school evaluations yet, but I'm hoping they're good. Rationale for the course. Well, as Carol mentioned, the course is frequently offered in business school core curriculum. So at the Wharton School, I just looked it up, they have a course, core curriculum called Ethics and Responsibility. When I went to business school in 1995 and 97 at Wharton, I had to take a similar course as well, and Robert H. Smith School also requires a similar course that I teach as well. It is a bit of an academic orphan in law school curriculum, and perhaps, as Carol suggested, perhaps this is a subject that's beyond the rules, beyond the regulations, the statutes, the case law. One of the things that I like about a course like this is it does take an interdisciplinary approach, business, economics, law, psychology, a little bit of philosophy, and it provides an exposure of the corporation beyond the statutes and the case laws of corporate governance or whatever compliance that there might be associated with the corporation. I also use a lot of business school case studies, and students find that they like working with these case studies because it really contextualizes the corporate and business decision making, and they are different from the highly abstract, stylized fact patterns of the appellate case law. And so I find that students really like this approach. So the course is really in two parts, although it's not really designated so in the syllabus, but I envision it as a two-part course. One is trying to conceptualize the corporation, the purpose of the corporation, the role of agency, and gatekeepers, and provide some sort of a model of these ideas and these issues. And then when that's done, there's a capstone case study that I use. It's a case study that is the symbol, I think, of organizational deviance, which is the Enron, the fall of Enron. And so the theory of the firm, so these readings might be familiar to those who teach corporations. So Burley and Means, Coase, the nature of the firm, William Allen's article, The Schizophrenic Conception of the Business Corporation, Easterbrook and Fischel, and oops, down at the bottom is Blair and Stout, team production. Seems to cut it off, but sorry about that. And for the purpose of the corporation, some pretty familiar cases in business association, Dodge versus Forge, Lenski, Barlow, Michael Jensen's Value Maximization and Stakeholder Theory. It's an article in the Business Ethics Quarterly. Milton Friedman's classic op-ed in the New York Times, as well as an article from Charles Handy that's in the Harvard Business Review. So agency. Eugene Fama, Agency Problems and the Theory of the Firm. Jensen and Meckling's article on the problem of agency. Stanley Milgram's Obedience to Authority, which is based upon his, I believe, 1960s studies, psychology research studies on how ordinary people will obey authority and to what extent they will go. And a little bit of vanity. My article, I do it not for vanity purposes, but there's a segment in the article that ties in these concepts together, I think, nicely. And so I provide that, and it provides a real nice summary for some of the topics that have been discussed. And of course, professionals and gatekeepers. Professor Kofi's book, Chapter 6, on gatekeepers. Professor Frankel's book, Trust and Honesty, Chapter 9, the shift from professions to businesses. And here is where I introduce some case studies. One is analyst conflict. It involves the .com era and the sell-side analysts and the conflicts that we saw there, or the conflict of interest. And it gets students to start thinking about conflict of interest, organizational design, And I segue then into the role of the professionals in the demise of Enron. So that's a nice case study. It takes a look at the role of attorneys, accountants, sell-side analysts, and credit rating agencies, and management consultants as well. And so the capstone then is a case study on Enron. I brought several copies. Here, it's a very thick 70-page, pretty dense case study, and we spend several hours just on that case study. And so anybody who's interested can grab a copy. I didn't bring copies for everyone, but there's some samples here. And it's based on Malcolm Salter's book, Innovation Corrupted. He's also the author of the case study. And it takes a look at the question of how did Enron collapse and what can we learn from it. And so the case study covers, of course, Enron is a huge catastrophe, and it's like a plane crash. There's a number of different factors that went in, and so here are some factors. And so in the class, we take a look at these factors: the business model, leadership, law and government, monitoring, hedging, and professionals. I highlighted hedging because this is a conference on transactions. We're teaching transactions. So here's a slide from my business school class, actually. The Rhythms hedge, so this was a hedge that Enron put in for merchant investment in Rhythms Net Communications. I think they had about a 50% stake in it. Enron was concerned about the volatility of earnings from an adverse stock price movement of Rhythms. Wanted to hedge this risk, but couldn't find a counterparty, so Enron creates its own counterparty, LJM1, which of course is run by Fastow. We take a look at how the deal was structured. So you can see it's complex, but basically LJM1 becomes the counterparty and issues put options to Enron so it can hedge the value in Rhythm's investment. And thereafter, we take a look at, well, what's the fundamental economic problem with this structure, and what are the fundamental ethical problems with this transaction structure. So we spend a lot of time taking a look at some, not all, they had lots, of the transactions that Enron engaged in. Rhythms led to LJM2, and so LJM2 involved other merchant portfolio hedging, and I put this up because we can see some of the Wall Street names that were involved in this scheme, as well as, of course, other professional advisors, accountants and lawyers were involved as well. Interesting thing is the IRR on the four Raptors, 193, 278, 2,500, 125% returns to these firms, and so these are some of the things that I think advisors should have been looking at. The minimum guarantee of 30% returns to these firms, and the questions that should have been asked was, how is this possible, and what really are the economics, what really are the ethical issues. So we take a look at the collapse of LJM2, which resulted in the October of 2001 third quarter press release that led to subsequently a few months thereafter in the collapse of Enron. We take a look at some of the accounting issues, some of the accounting revisions that were associated with LJM2. Sorry about that. It should be debits, credits, PowerPoint mixed it up a little bit. All right. Then we go into, so that's part one. So part one was taking a look at theory of the firm, the agency, the purpose of the corporation, the role of professionals and gatekeepers, and capping it off with a big case study. And then part two, because this topic of corporate ethics and corporate social responsibility can be extremely broad. Here I try to take a look at some discrete topics. So trust in business, competition and strategy, ethics overseas, and the financial crisis. And I'll go over the second part of the class. So trust in business, Blair and Stout's article in the Pennsylvania Law Review, trustworthy, and behavioral foundations of corporate law. Some of these readings are excerpted, so they're not reading all of the articles. Karana and Pick, the social nature of boards. And we cap it off with a case study on the Hewlett-Packard, The War Within. I brought copies of that as well, several copies here. That's a really nice case study. I like it quite a lot because we talk about corporate governance in law school. We talk about the rules of corporate governance in law school. But here's a case study of how we have a legendary American corporation and the board of a legendary American corporation just completely going off the rails. And how did it happen? And what were the dynamics that led to this scandal? And so the case study there does a really nice job of talking about the personality, talking about the events, talking about the merger of Hewlett-Packard and Compaq, and the role of the CEO and leadership and the personality and the relationship between the CEO and the board. And all of these factors, once again, almost like a plane crash, a number of different factors aligning up, the stars are aligning up for this big catastrophe, and it happens. And so this case study does a nice job of illustrating some of the things in board governance that can go wrong. So competition and strategy is another discrete topic that I picked out. And here some of the readings are Marty Ascend, Does Business Ethics Make Economic Sense? Michael Porter and Michael Kramer, Strategy and Society, the link between competitive advantage and corporate social responsibility. And once again, I use a case study that illustrates some of the theoretical readings in this area. And the case study that I picked out is Walmart and sustainability. And so how can Walmart pursue profits and sustainability at the same time? And this case study talks about supply chain management issues. And this case study focuses on seafood, textiles, organic cotton, and e-waste. And what I like about this case study as well is that there's a significant role for NGOs and how they play in helping achieve Walmart's sustainability goals. And so at the University of Maryland, of course, we have a lot of students who are interested in doing work in public policy and going out and doing public interest work. And what I tell my students is that if you want to actually work for an NGO or do public interest, you should learn a little bit about business. Instead of taking that additional course on public policy, take a course on supply chain management, take a course on business strategy. And I think that may give you a perspective on how to work with private firms and private corporations. Ethics overseas. So I use a case of IKEA's global sourcing challenge and the issue of child labor. This is a nice case study because it comes with a video clip of the CEO and the business manager in charge of addressing this problem. And you get to see their perspective, and they're real, they're human beings. You see their picture, you see them talk, and there's a connection. It makes this problem concrete. It contextualizes the problem. And so this is I found the students liked this as well. And finally, the financial crisis. In light of the historic nature of the financial crisis in both the law school and the business school class, I asked them to research a topic and give a group presentation. And so some of the presentations have been pretty interesting. In addition to that, I used two case studies. One is the J.P. Morgan acquisition of Bear Stearns. And the other is a case study that I wrote up. It's the Bank of America Merrill Lynch merger. I wrote it up in this article on the Fortnite Law Review. It's part one of the Law Review. And so I brought some copies here as well. I found that I really enjoyed writing the case study. It was fun. It was a lot of fun compiling the materials from various sources and putting a case study together. And so we go over the Bank of America Merrill Lynch merger. So here's the timeline. And essentially, the issue in the Bank of America Merrill Lynch merger was, could Bank of America terminate the merger after signing of the merger agreement, and upon learning that Merrill Lynch was pretty scary stuff, that on a daily basis billion-dollar losses were accruing, and so there was at one point an issue in which the management of Bank of America got cold feet and was thinking about actually terminating the merger, and the government stepped in, and there was a whole lot of events that were associated with the closing of the transaction, led to a number of congressional testimonies by Hank Paulson, Ben Bernanke, and Ken Lewis. And we go over some of the timeline. We go over some of the legal issues of terminating the transaction. Ultimately, of course, the transaction did close, and the government had a heavy hand in that. And so I think properly, it closed properly, because here's the MAC clause. There was no material adverse change. That was the opinion by the Federal Reserve. That was the opinion by the Bank of America General Counsel before he got fired for taking that position. And also, I've taken a look at that clause myself, and I don't think that there was material adverse change. In any event, so that's the deal side. And in terms of the social responsibility side, I asked my students, well, let's take a counterfactual. Suppose Bank of America could have actually terminated the merger, that it was a material adverse change. Should they have done so in the height of the financial crisis? So this was the fourth quarter of 2008. The stock market was falling off the cliff, 40% decline in the equity markets. And so we take a look at the questions of what can the board do under corporate law, what should the law be as to the directors, and what should the board do under these circumstances. These circumstances in which Bank of America is uniquely positioned to come in and provide some sort of a rescue, just as, for example, that Bear Stearns, JP Morgan was in a position to do so back in March of that year as well. So we take a look at some of the issues in corporate law, shareholder primacy, business judgment rule, stakeholders, philanthropy, and Section 122, subsection 12, which has this interesting language in it. The corporation has the power to transact any lawful business, which the corporation's board of directors shall be found to be the aid of government authority. And so that's the course. So student evaluation and feedback. So here's some representative. I try to go out and pick out some representative comments from the course evaluations. Law school students like the course, at least that's what the evaluations show. And they like the course for two reasons, I think. One is the interdisciplinary nature and focus of the course. And they like the pedagogy, they like the case studies quite a bit. And I think my reading is that they like it because it contextualizes the problem quite a bit. That the case studies that the business schools use are quite rich in facts and ambiguities. And so they like working through what appears to be a real live problem. Some of the negative comments. There's some discomfort with the economic and business concepts, and also the course is quite heavy in terms of the reading and workload, and that seems to be a universal comment that I get back, which is that they really don't like the heavy workload aspect of it. I haven't gotten back my evaluations from my business school course yet. I've seen some of the written comments, and they range from truly awful to one of the best course in business school that I've taken thus far. So there seems to be some sort of a range, and I'll have a better idea once I get the full evaluations back. Moving forward, some of the things that I'm thinking about, offering it up jointly, as Professor Frankel and Professor Fagan have hopes to do, or I don't know, do you do it now, or?
We have very small representation for the business school.
Okay. Yeah, I think possibly opening up JD and MBA students and having a mix would be a good idea. I have noticed that there are differences. There are systemic differences between law school students and business school students, and it would be really nice to actually get a joint class together. Continue to reinvent the course materials and update it with current events. And another thing that I'm thinking about is perhaps developing more case studies. I really enjoyed quite a bit writing the case study. That's part one of the article. As a way of compiling the history for one, and two, using it with my students, and so maybe doing more case studies, develop simulations of ethical scenarios. I haven't done that yet, but I'm thinking about it, and perhaps maybe there's a need for a casebook that's a supplement to this typical business association class. And so that's those are my two courses at the school. So I've had a fun time teaching the course. It's been very informative for me. I've enjoyed it. I've enjoyed the papers. One nice thing about it is that I think at this point I'm starting to get some very high quality papers. One of which I think from my past class that can actually can perhaps be published. There's a publishable, it's a publishable quality, and so I'm encouraging that student to really redraft the paper and perhaps try to get it published somewhere. So, any questions before I sit down? Yes.
Robert, I'm Lyman Johnson. My question is, how comfortable are students in actually engaging in ethical moral discourse? I mean, maybe the way to start the question is, what sort of resources and arguments and authorities will they invoke as they state their positions in these various case studies?
Yeah.
Could you repeat the question?
Yes. How comfortable are the students in talking about social ethics and the ambiguities and the gray areas that are associated with that topic or issue? The answer is my law school students are quite comfortable, and I think that they are comfortable in discussing ambiguities, discussing moral issues, discussing what is the right thing to do, discussing, of course, the law. Where I found that law school students are not comfortable are in the economic concepts and some of the finance that are embedded in some of the case studies. Now, the flip side to that is with business school students, I've noticed that some students are not as comfortable with the qualitative, the subjective, the ambiguous concepts, and they're used. Some of them were used to just simply modeling and getting the answer, accounting or finance or corporate finance, and they were not used to open-ended questions. Also, what I've noticed about the business school students is that many of them come with a very heavy predisposition towards shareholder privacy, and so that also comes as a shock to them. And so there's some active discussion that's in the business school. So that's why I say that it would be really interesting to have the JD students and the MBA students mixed in a course. And I'm hoping to do that. So one of the things that I'm hoping to do on a broader question is to perhaps have some curricular exchange between the Maryland Law School and the Maryland Business School, in which students can more readily take course offerings from both schools. So, yes?
My question may be sort of related. I've taught business ethics both in two MBA programs and at law school. And I guess my question is, where do the students get the tools to make strong counter arguments? And just as an example, you showed the supply chain thing with IKEA and using, third world labor. I've got the gray hairs. I taught it as the Nike factory problem. Some of you may remember that. And one of the things I found is I could get students to make the argument for doing the right thing. I could get students to make the argument that you suggested your business students might be more comfortable with. Oh, you can't tell the corporation what to do. You're undermining maximizing the profits. I don't think that I could get the students on their own to make the kind of argument, for example, that Paul Krugman has made, which is that in the long run, using third world labor, even at 10 or 20 cents a day, is actually beneficial to the people in those countries. I had to give them that reading to give them the tool to make that kind of argument. And so one of the limitations I found of business school cases is there's a lot of richness and context, but there isn't always a development of the dilemma of an ethical problem. Enron kind of seems after the fact, well, obviously it was both illegal and unethical. How do you give them the tools to see the nuance, the dilemma aspects to these?
Sure. The question is, how do I give the students the tools to see various aspects of the ethical dilemma? Just to summarize it in short, record here. A couple of answers. One, through a lot of the readings. So the course is actually has a fair amount of reading and reading from different perspectives, and so they're more theoretically oriented readings as well. And I always get, as I said, as a part of the evaluation, just a lot of criticism for very, very heavy reading load, very heavy workload. I have to do it though, to address the concern that you just raised. The other is sometimes I will break up the class discussion and have, for example, executive management. Break up the students into groups and give them a simulation. Just say you're part of the management team. Talk about this. How do you address this? Or you're the board of directors and talk about that. And what I've noticed is in observing these discussions that many different perspectives do come in, and they start to discuss the richness and the ambiguities of the fact pattern. So okay.
Okay.
All right.
Okay. I'll talk for a bit about teaching business ethics in the context of existing courses, the integrated approach. And my approach is probably more on a micro level too, more of the day-to-day issues that you would deal with in the practice of law. And I think lots of different approaches are valid and would all be good. To step back and look at a case study is something I value as well. But the focus in these courses is really for them to see how to personalize it, to see how they will be faced with issues that daily in representing business clients. This is not just an Enron problem that exists out here and it's not going to ever affect us because we'd never do anything that bad. It's really daily the little things that can happen that sometimes can lead to the erosion or a corrupt corporate culture. But it's that they have a role in playing and counseling their client through just the small day-to-day kinds of things. So that's the context. And I use my transactional skills courses. My focus at Georgia is to teach about the practice of law. And so there's great opportunity in these courses to raise these sort of daily issues. And I'm curious how many of you teach transactional skills courses, or what I call practice-based courses. those who didn't raise your hand, are you more on the doctrinal side? Okay. Because I think there's a lot that can be incorporated into both as well. But my particular focus is from the transactional skills side. It does give students an opportunity to come face-to-face with their own personal views on things, sometimes that they haven't really thought about before. It's important for them to hear their peers' views, who are often quite different. It is important for them to really figure out how they would react to a particular circumstance before it actually happens. To make them realize this is going to be a part of your practice. Now let's practice when it doesn't really count, so they'll be prepared for future. What I've done is I've just put together, more of these micro case studies for them to help them to look at things from a very practical and a proactive point of view. And I've provided some of those materials. You have just a sampling of the kinds of situations that involve ethical issues that I raised with my students. And to help them, because some of them aren't comfortable talking in a big group about some of their views on some of these complex issues, I usually do divide them and have them buzz with smaller groups, and then we bring the discussion together. And they're very forthright, generally. I'm always amazed at the different perspectives and the different thoughts that students have and approaches that they would have to these situations, and that there's not always a right and wrong. Back to the the business school students wanting that right answer. This can be tough with law students too, and to realize that sometimes there are very complex issues, and they have to understand that there may not be always the right and wrong, despite that it's the right thing to do. That they have to look at all these nuances and figure out what they're most comfortable with. Where do they fit into this? There are 3 courses that I teach at Georgia, transactional skills courses. I teach an anatomy of an M&A deal, where we take a deal from start to finish, a business negotiations class, and then, of course, corporate counsel externship. And our students not only have field experience working in a legal department, but we have a very intensive seminar where we talk about topics that are unique and relevant for corporate counsel. And all of those courses provide a great opportunity to address a lot of these business ethics issues. In the M&A class, we look at the kinds of things that could come up daily in a transactional context that involve ethical dilemmas that a client may have, or that the lawyer may have as a result of what the client's asking them to do. And we do a simulated negotiation involving some disclosure and non-disclosure issues. There's a pretty standard one, the confectioner something, forgotten the name of that one exactly, but I did a variation. I've come up with some of my own. And those kinds of discussions are good, where they actually have to role play how they would deal with ethical dilemmas. There are some here that I've mentioned in the materials. One is actually more from the lawyer's standpoint. This always generates some really interesting discussion about a situation where you're in the course of a transaction. It's under the M&A listing. It's the B problem, where the seller sends a marked draft that was obviously not intended for you. How do you react to that situation? Do you tell your client? Do you go and have a conversation with your client about all these secrets that you've now learned from these comments? And what would you expect law students to say? What do you think if you threw that problem out to your client, where you've received a marked draft from the other side? Obviously, it was not intended for you because they put in their strategy and their comments to their client in the margins. What do you as a lawyer do in that situation? What do you think a law student, what do you think some of the responses? There are a myriad. It's not one or two. It's a myriad of responses.
I think they say tough. That's tough luck for the other lawyer.
There's the tough luck theory. Yeah, I'm not my brother's keeper. It's their problem. What else?
What does the code tell me to do?
There's that, definitely. And what do you think that they what conclusion do you think they reach with that?
I don't teach that.
That's an easy answer.
We use a similar situation in my deal skills class, and I'm always amazed every semester that the students will reference professional courtesy. And they say, oh, as a professional courtesy, we would call the other lawyer.
Or
The one thing I push the kids to do is ask the question, what would their grandmother do? Because again, I don't understand, I come back, I don't see why this is a peculiarly legal question. It comes up in life all the time, with people you have relationships with. And as a starting point, either law is imposing a tougher, or alternatively somehow law is being used as an excuse that somehow we're lawyers and we don't have to. And the students actually begin to respond attentively to the notion that they're not special.
that's a good point. The grandmother approach, the grandmother theory, that's good. And one I heard recently was, oh, I think that I would say the other side put those notes in to throw me off. That it's a subterfuge, it's deception. I don't trust. And I'm thinking, we have no trust here. But what a theory. Now, that's how they rationalized it away, Sure, I'm going to look at it. Because it could just all be a ruse. That was interesting. It just is mind-boggling but it generates that discussion that, let's think about it now, because it will happen in your practice and daily life, as you said, too. But just to think about what are your reactions and why are you reacting that way. Simple things, maybe ordinary things, but they don't always think about that. In the business negotiations class, I really like the book Bargaining for Advantage by Richard Shell. I don't know if you have used it, but he discusses the 3 schools of bargaining ethics. It's a game, it's all a game. The poker school, the do the right thing even if it hurts idealist school, and then the what goes around comes around pragmatist school, which is sort of a combination of the two. It has a really good discussion about that, some great examples, and that generates a lot of discussion in our class. And I have them write about where do they think they fall in this, or in between things, or where do they fall on this scale of ethics. They journal about that, and then we discuss several ethical situations in light of each school of thought. If you were this school of thought, how would you react? And several of those examples are listed in the materials as well. And then the last one, the seminar portion of my corporate counsel externship is just a ripe opportunity to have a lot of discussion about business ethics. As a former general counsel too, I have lots of personal experience with that. And we discuss it throughout the course, just how that just permeates everything you do in the practice of law generally. And the role of the in-house counsel is a little unique because you have a closer business relationship with your client as well. You are very much of a business advisor as well as a legal advisor. We take a look at codes of conduct, what a company says its corporate culture and ethical atmosphere is, and we take those apart and we look at lots of different companies, and we give them lots of situations that they may face. And then they look at them in light of these codes of conduct. So that's kind of real world stuff. How would a company under its code of conduct react? But that's something you as a lawyer need to be aware of their code of conduct and how that might influence your own advice and decisions. I invite a lot of in-house counsel in too, and one of the favorite panels we had was where the in-house counsel presented a business ethics situation, a real dilemma that they faced, but didn't tell them how they handled it. They asked them, how would you handle this? And then they would, come up and brainstorm, and then the in-house counsel said, this is how we handled it. What do you think? And that provides some very rich discussion, real world, daily kind of stuff at the ground level with a general in-house counsel. And then one of the really fun things we did in the course too is where they had to simulate being a general counsel. And other members of the class were the senior management team. And I presented some ethical problems as well as some legal issues. And they only had 24 hours notice. I gave them the situations. The senior management team had to prepare and the general counsel had to prepare for the discussion. And there was an exchange, where the senior counsel really pressed them on things, well, isn't this okay? I don't understand why that's not okay. And then the general counsel had to advise in the heat of the moment how they would respond or react. And it gave them that practice experience. This is, you're on the, in the hot seat, and you've got to deal with this and respond. And that was a lot of fun. They actually sweated it out beforehand, and then they came away saying, boy, that was a lot of fun. And it gave them really great experience. So some of the discussions here, some of the ideas, I think a couple of them maybe here in the corporate counsel section that we used. I think we used at least one of these. But there's an example in here where very timely topic where a furlough is being proposed to the company, and you find out as the lawyer that the president of the business unit that's going to be affected by the furlough is going to get a bonus if they do the furlough and they cut the costs and they're going to make their budget, and then they're going to be able to get a bonus. And so the president of the company comes to you as general counsel and said, what are the legal issues involved with this furlough? Well, it's perfectly legal. You can have a furlough. Perfectly legal. Here, we can do these things. This is fine, legally. But then when you realize that there could be broader implications for this, long-term implications, do you even raise those? Are you comfortable raising those to the president? That he may have no employees at the end of the day. They may furlough a little longer. Do you have that conversation or not? Do you feel comfortable? And we talk about that. That kind of issue. That's an example of something perfectly legal to do, but there may be some ethical implications. And does the lawyer even have a role in raising those? We talk about that. The other example here is where you discover that you haven't been doing something you should have been doing. There's a breach of contract, but they're saying no harm, no foul. It's not really a big deal. We don't really want to do anything about this breach of contract. And how do you respond as a general counsel to that as well? Daily kinds of things that can happen. So that's kind of the approach that I've taken, is really just to push them, ask them lots of questions, play devil's advocate, and try to get them to really think about issues that are not necessarily the big, bad, egregious stuff, but just the daily kinds of things that can impact their lives and their practice. Any questions about that, or ideas, suggestions? Okay.
My question is, all simulations obviously have an artificiality to them, but particularly in this area, and I haven't done anything like this, but in roughly analogous things, you'll hear them be very idealistic, and then you say, right, and then how do you get them to say, right, but if they don't like you, you're fired. This is the idea that 2Ls don't have ethical problems, 50 associates have ethical problems, and because it's all so contrived, and until you're there and you're going to be in all the kind of how, other than just sort of telling them that, do you have a way to attempt to situate them where their own sort of standing within the organization, the firm, or whatever, is on the line here, and it's not just this sort of think about it, but how will you be perceived, and how does when do you take the hit personally? How do you insert that into the kind of fact pattern that you set up for them?
Well, I do try to push them on those kinds of discussions. And there are some fact patterns where I've used some fact patterns where it's just not clear because you realize there's some real personal impacts for you too. But mainly it's just pushing them to think about the issue from a more realistic standpoint, that it's not just this moral game we're playing, that there's right and wrong, to help them realize there are a lot of nuances to this, and at least to help them start thinking about and recognizing it without the idea that we're going to have an answer at the end of the day. But that's my goal, is to really push them hard in thinking. And that's when I play the devil's advocate. Well, what about this? You know, you could lose your job. Think about that. You got a child at home. You know, you could lose your job over this. What do you do?
I'd like to take a respectful exception in some points in that, to what one of our colleagues said, in that I've developed case studies on the HP pretexting scandal and Arthur Anderson's behavior, the in-house counsel behavior, and the Enron scandal. And I think in some ways lawyers, not that we're special, but there's a wealth of ethical resources that we have. And if I may, specifically, a couple years ago, mining of metadata. Every document that's created has metadata. And it can be a trick bag because you can see attorney-client privileged communications within the metadata. So I worked up a nice little case study about that. Mm-hmm. And at one point, the state bar associations were divided. Colorado had an opinion that went one way, a couple of the East Coast states had opinions that went the other way. But there were resources that lawyers could go to, that if an in-house client was saying, no, if this idiot's sending over a draft contract full of metadata and I can see who all has reviewed it, I'm going to take advantage of that in the negotiation. So my respectful exception is that there is a more richly resourced set of ethical standards out there for lawyers, and it's just not what a layperson might do it. And in the HP pretexting scandal, not only is it a great exercise to look at your duty to the board and the entity and all of that, but the outside investigators who were employed actually took felony convictions in Colorado. So if the in-house lawyer was thinking through it, she would have seen, well, one of the reasons I know this is not a good thing to do is these guys just bought themselves felony indictments. So I think that lawyers are under an obligation to think about these standards in a more rigorous fashion and not on a broader moral scale.
Mm-hmm. I think that's a good point. I think that segues very nicely to what Tamar is going to be talking about. And we can take some more questions at the end. I'd like for you to have as much time as you can, Tamar.
Thank you very much. Let me stand. I was listening here and thinking, first thing I said to Carol, I'm not talking about ethics, I'm talking about law. But then realized I should eat my words because I'm talking to some extent about ethics as well. One of the themes that the entire course of Trust and Honesty in Real Life is concerned about is the slippery slope. You start with something small. It's not really something very serious, and then you continue, and you'll find yourself at the end having violated the law. And as far as lawyers are concerned, raising the awareness of that slippery slope at an early age, at an early stage, may be very valuable, both for the clients and for the lawyers as well. So I take it back and say there is some element of ethics in this course. This course is combined or is composed of two books which students have to read. One is mine. It was the only book I ever wrote for the public. It's not necessarily a legal book for lawyers. And the other is Mark Fagan, who's sitting here, and who wrote case studies and role play. So we have three pieces. One is reading, getting the background, not very long. The other one is these case studies. After the case studies, we have three types of questions. One is the law. The other one is the business or finance. And the third one is public policy. And we believe that any of these issues requires a lawyer to look at these three, not only the one aspect, but the three aspects. Now, what we have done is created three main themes. One theme is everybody does it. Hey, why shouldn't we do it? We're fools. So this is one theme, and we have a number of case studies and role play with respect to that. The other one is institutional culture. It's not merely everybody does it. There's no other way except the way we do it. And we have been doing it for a long time. And I'll talk about the examples that we gave. And the third one is, okay, we've lost the trust. How do we gain it? Because this is another element. So, starting with everybody does it, and this is one example that I would like to kind of expand a bit. We took a Ponzi scheme at the time when Madoff was still behind the shadows. He afterwards emerged. But what the students discover is that every entrepreneur could be a Ponzi schemer. There comes a point in the entrepreneur's life when he or she realizes it doesn't work. And then there is no business anymore to pay the investors, and the only source is other investors. That's a Ponzi scheme. That's very simple. We did not manage to recruit a lot of business students. So instead, we asked some speaker to come and play the role. And I would like to describe to you what happened in that case with the role play, because it was interesting. The story was that there was a young girl. She had an idea. She went to a venture capitalist, gave her $500,000. She tried, and somebody beat her to it, and she lost $500,000, and she has another idea to expand it. She needs more money and more time. And we asked the students to prepare her speech to the venture capitalist. What was interesting in that case is that the students tried very hard to kind of put under the carpet the fact that she didn't succeed, the fact that she lost the money and so on, and focus on the more money that they asked for and what would be then the venture capitalists' part in the successful venture. And then our friend, who is a very good lawyer, who has spent a lot of time with venture capitalists, said to them, look, every venture capitalist knows that it would take more money and more time. But if he can't trust you, it would take 2 seconds and he's been out. And therefore, this conversation would not last very long. Goodbye. And they were stunned. And one of them said, and you wouldn't sue us? And he said, sue you? For what? You don't have a penny. You're a young woman. What would we sue you for? After that class, one of the students came to me and said, boy, that was so embarrassing, you know. And then his face lighted. And he said, but it's good, I know it now. Yes? This, in some respects, what we do in law school is we give them litigation, yes? Because we use the cases. It's good to use the cases, but as a result of it, their typical kind of tendency was to say, we'll be sued, so we had to protect ourselves. And this happens time and again. So we thought that was one example of learning that is useful. We did the same with market timing in the mutual fund area, where everybody was doing it. Well, not everybody, but 30% of the mutual funds were doing it. That was good enough percentage. And we again worked it out. What was interesting also is that the SEC didn't do anything about it until Elliot Spitzer raised the flag. And then, of course, the thing was over. And the third one was a sale of lemons. It's another case. We took it from a case, but gave them the facts. And here the problem was, there was nobody liable. The manufacturer was not liable, the dealer was not liable. And they had to look at the law and see how the law attempts to answer the question. The second theme of the book was, as I said, the environment. I don't know how many of you, you're young, but many of you may have heard about E.F. Hutton. They were I see somebody kind of looking. They were the brokerage firm, the one and only, yes? They were sold at the end in a fire sale for nothing. There were two things that happened in that group. One was the culture, yes? The brokers could do anything they want so long as they got the money. And the second thing was the environment changed, what was called the Big Bang, and the fixed commissions were eliminated. They had to begin to compete. The result was that they needed money and they couldn't bring it from the business. They began check kiting. Slippery slope, a little bit at a time. At first it was legal, then it was not so legal, not quite. And then it was illegal. Well, by the time they finished with 2,000 not cases, but claims against them, and here's the last point. They took something which was dangerous to the banking system. Their clients were okay. But the banking system was threatened by this. This was time of inflation. And the check kiting enabled them simply to get interest-free money. 12% is not so bad. And that's what they got. So students, again, have some heightened recognition of slippery slope and where it could lead. We also picked on poor man, Grasso. I don't know if you know that story, but anyway, this is executive compensation in a very interesting way, and we dealt with that as well. And the fourth one was the conflict of the interest of a weak child and the good of society. And this is the one thing, after I'm done, that I would very much ask Mark to tell you some more about it, because that's our highlighting the interest of the public versus the interest of a weak child. The second, or I may have, this was the second. And the third part is how do you resurrect fallen trust? And what we did here was first of all to look at the conflict between seeing things as a contract and seeing things as a fiduciary duty. I will not, I just want to highlight here, fiduciary duty brings us to corporate, to a variety of other things where people have to take into consideration other people's interests. In contract, you take care of yourself, I take care of me. And wherever we end, that's okay. We highlighted the difference and evaluated the choice of the law. The second module was subprime. Who could avoid that? We couldn't resist the temptation. And finally, we did deal with whistleblowers. Talked about Enron, but the interesting part is the role and the future of Sharon Watkins. She did not go to the police. She went to her boss. She wrote him a letter. She said, "What are we doing? Let's fix it. We're going the wrong way." When he didn't answer, she sold her stock. But she remained there. And so you have a legal question about selling the stock. There's Rule 10b-5, if somebody knows about it. It's insider trading, yes? And yet, at the same time, you have a problem when you owe fiduciary duty to the employer on the one hand, and you owe some duties not to violate the law on the other hand. So there was quite a bit of discussion about that. And the last thing, we found that sometimes it's good to push students to think outside the box. So here was a role play, a hospital that is going down the drain, and a CEO that is not a doctor who is trying to fix it. And we had a group of CEOs, we had a group of doctors, and we had a group of the people who wrote the demands to the insurance, and there was another group as well. The CEO said, you have machines that cost a lot, and they are used only 40%. Start using them 60%. There would be nothing wrong with that, and then you'll cover more of the expenses. The doctor said, not in your life. We are not going to take to use these machines if we don't need to use these machines. But then students came, and it was very interesting. One group one year came with the idea that they were going to ask other smaller hospitals whether they need such machines, and then kind of expand the usage together with some cost, but they made the calculation. In other words, it was neither nor. The other one said, shut them down. So in both cases, to some extent, they were pushed to think outside the box. And we thought that was a useful way of trying to solve a problem. As far as the claimants of the insurance was concerned, there was no question. They said, we are not. Oh, as to that, the CEO said, why don't you round the claim a little up, just a little bit, yes? At the end, it will come to a larger amount. the group of students said, we are not going to do that. We were trusted. The insurance company never asked us about this, and we are not going to do that. So at least we didn't tell them anything. They came to that conclusion. They had some arguments among themselves. I want to say not one word, maybe two, about teaching together. Usually Mark outlines the class. We agree without much ado about the division of the subject. In order not to get into each other's statement, one of us who is not doing the talking is sitting down. When that person stands up, then it's a signal, I want to say something. Then you wait to the sentence, and then the other person talks. What has happened is that this simple signaling has said to one of the students, said in the comments, these two teachers kind of had, how did they call it, a seamless kind of agreement or presentation, and I think that was very helpful. We give students about 10 minutes to discuss among themselves and come to an agreement. They decide who the spokesman is, and sometimes they decide that all of them are going to be spokesmen. That's fine too, be my guest. We assign them 2 papers. We don't give grades to the first one, we give comments. The second one, we take them together. We value about 40% of the grade for participation in class. They know it. They know it in advance. So I think, Mark, shoot.
Thank you. One of the things we had hoped we could do was just give you a flavor for how we actually teach the class as well. Tamar did a phenomenal job. I sat here and said, wow, that's a really good course. In understanding how what we do. But I wanted to try and show you a little bit of how we do it as well. All right, someone show me a slideshow. Here we go. Had you been attending our class, you would have had this particular case study is about 10 pages long, and you would have read it in advance. Given that we didn't get it to you in advance, I'm going to take literally a couple of minutes and blow you very quickly through this case study so we can actually get to the discussion. This actually builds very nicely, Robert, on your comment about conflicts of interest being one of the core issues that are associated with these general descriptors, whether it's ethics, trust, and honesty. And this is one in particular that deals with lead paint. We like it because hopefully you'll see as we go through, it sets up some very interesting tension and potential conflicts. So just a quick background, lead paint poisoning does a lot of damage and it doesn't take a lot. You can see from relatively small concentrations where you have hearing impaired, things like that. Relatively small doses, 150, you get death. So this is something that is a very important issue. It turns out the group that's most influenced by it tend to be minorities, disadvantaged from an economic perspective as well. Not terribly surprising. Largely because lead paint was used until the 1970s. It was banned after that. So if you live in old housing stock, you're likely to have lead paint. How does it come about? Well, it's dominantly through ingestion. If you think of any old building peeling paint, you're likely to see it. What's interesting in particular about lead paint poisoning is it's completely preventable. This is something you can solve. That paint I just showed you a moment ago, you remediate it, you remove it, you're not going to have poisoning. The issue is, though, that abatement is expensive. So you can do your house, some houses can be done for $5,000, $10,000, $15,000. So you think about it, for the population we're concerned about, economically disadvantaged, that's a lot of money and unlikely. Also, tends to be a landlord burden, especially for this population. So the question very quickly becomes, what can I do to try and maximize the dollars I have in terms of reducing lead paint impact? Enter an organization called the Kennedy Krieger Institute. It's associated with Johns Hopkins University, and it works in Center City, Baltimore. It has been part of the community for a long time, and it views its mission as making the health outcomes for that community better. They understand, again, this idea that there's a limited amount of resources that are available, so they create a study, and they say, well, for a given amount of money, how many homes can I remediate? Simple question. And what they do is they say, well, let's try different levels of remediation. So the first one, $1,650, gets you the elimination of peeled paint. So basically just clean up what we have. The next step up, a middle level, is you put sealants in the most vulnerable places. The third one up at $7,000 is you replace windows and encapsulate doors, which are, again, the places that are most likely to have the peeling paint. So you can see 3 levels of remediation. What do you think the study says? What do you think, excuse me, what do you think the study does? How do you think it works? What are they going to do? So if you're a research designer responsible for this, how would you create the study? This is where the 40% of their grade comes in. So they raise their hands and answer. So here's where the 40% of yours comes in. What would you do? We got some business people, we got some lawyers. Conceptually, what would you do? How would you set up an experiment? Okay, you get a buy on this one, but we're going to get to a legal question in a minute, and I'll expect that. What they do is they say, let's take 100 houses, let's remediate a third of them at the low level, a third of them at the medium level, and a third of them at the high level, and let's see what happens to the outcomes from having done that. So they go out and they recruit some landlords to do the remediation. And we've already got a chuckle over in the corner here. He's already gearing up for what this is going to look like. So you have to have, the landlord agrees to participate. They've got to go out and recruit a family to move in. You could argue someone who's in the place, that's okay. But you have to have at least one kid under 5, because that's what we're interested in. This is a childhood issue. They have to live there for at least 2 years, because this is a 2-year study. Oh, by the way, they go to CDC, just down the road. They go to EPA, they go to Johns Hopkins, and it goes through all the ethical review boards. It's approved. And the way in which they're going to do this is they're going to keep track of the amount of lead in the air, as well as do testing of the children as we go along in terms of their blood lead levels. And they're going to keep track of it. They're going to do it in 2 methods. The dust wipe method, literally you take the rag, you go like this, you put it in a machine and it tells you. And they also have a cyclone vacuum. It's just like your vacuum cleaner sucks up the air and does the analysis that way. And they're going to report the findings to the participants. Guess what? I won't take you through the details. It has a great impact. No matter which level of remediation you do, you get an immediate improvement, and it a little bit levels off and continues on. This is good news. But here's the problem. For most people, it's a great outcome. But for a few, it isn't so great. One of the few is a kid named Myron Higgins. African American, single mom, quite poor. Here's what happens. They do this. They're about 2/3 of the way through the study, so we're 15 months into the study. They get the lead levels from his blood, and they discover it ain't elevated. Turns out that they also knew from a month earlier that the ambient air lead was also higher. But not with the dust wipe method, only with the cyclone method. They didn't tell anyone. When they discover in his blood that he actually has elevated levels, they go through the appropriate reporting channels, and it becomes quite a to-do. We don't know what actually happens to Myron. I think for anyone who's a parent in the room, it's one of those things, you don't know what happened to your kid if they were exposed to lead levels. You just simply don't know. There is no counterfactual. So as you can imagine, Myron Higgins' mother does get some legal aid, and she sues KKI. And her argument is, when she goes to court, that they owed her a duty, and that duty was to inform her of the lead levels when it was in the air, and they failed to do that. In addition, she argues that she gave them a false sense of security. They gave her a false sense of security. KKI listens to this, goes to trial court, and says, we want to move for dismissal because we don't owe a duty. We are nothing more than an institutional volunteer. What do you think the trial court does? I know I'm not giving you many facts and it's a little unfair, but what do you think they do?
They throw it out.
They throw it out. They say, you're right. There is no duty to test. You are an institutional volunteer. They signed a consent form. And, oh, that's a good point, thank you very much. They do get compensated for the study. Every time they come into the home, they give the family $5. And oh, by the way, they give the kids T-shirts and socks and gloves in the winter. Compensation. Higgins takes it and goes to the appeals court. The appeals court takes it and looks at some three key areas. They look at, is there a special relationship that exists? Does the consent create a duty? And was the danger foreseeable? What do you think the appellate court comes back with? Okay, we're running out of time, I'll tell you. They come back and say, wait a minute, there is a duty here, clearly. This is something where there was foreseeable risk. The consent was signed by someone who has no power and no information. The consent says, I'm going to tell you if you have elevated levels, and you didn't tell them. Remand it back to trial court. It's facts, and we ought to get it on the table. Interestingly, the court, though, takes another step. They go on to pontificate a bit. What do they pontificate about? They pontificate first about therapeutic versus non-therapeutic research. They differentiate and they say, in non-therapeutic research, where the individual doesn't have anything to gain but has everything to lose, you create a duty that is much higher than if it were therapeutic. Therapeutic in the sense that it's going to help you. You got a problem, it's a test drug to help. That they differentiate. They go on to talk about the Tuskegee syphilis studies and draw an analogy with that in what's being done. They go on and chastise, quite elaborately, the study design, etc. It is a unanimous opinion. There's one dissenter, and the dissent isn't about the outcome, it's about the process. What do you think the dissenter complains about? Where are we as a court getting into public policy issues? Who are we to be talking and pontificating? That's not our job. Our job is to determine, should it go back to facts or not. Interestingly, we lose sight of the case goes away. It's settled along the way, and we don't know how much and what exactly happened. But what I do want to come back to is KKI's response. If anyone lived in the Washington area, you probably remember the headlines. This is kind of late 90s. Johns Hopkins endangering children. So KKI comes back and says, wait a minute. We had good research. We got all those approvals. What did we do wrong? And oh, by the way, you're tainting our scientists. And if you can't do studies on children, if you can't write a consent that's good enough to be able to do that, then how on earth would we ever test these kinds of things? So that's the context. The way we try and do the session is make it interactive, and for their 40%, they do have to come back and respond to these kinds of things. But to tie back to how Tamar kind of gave us some structure, we have the series of law questions, so they actually have to understand, look at that consent form. What's in it, what's not in it, is it viable, does it create a duty? So she's kind of charging away down the path on making them be good lawyers. I'm trying to get them to think about the business side and the public policy side. This is more of a policy case than a business case. And get them to think about that question that KKI represents of, well, how do you test things for children? That's a real issue. What are you going to do? And then coming back, I think that maybe it was your question earlier of how do you force the students to really kind of think about the real implications of it. We close out talking about why didn't KKI just tell them? We got elevated lead levels in your air when it first happened. So that's a question for you. Why would they not do it? Because what? It ruins the study. And therein lies the conflict of interest. So you're a researcher, you got a couple of $1 million, you're trying to get your dissertation done, you're almost at the end. So what do you do? And so that's the context we try and force the students to have to think about. What would you really do if that were the case? Would you have the guts to pull the plug? So with that, I'll turn it back and appreciate the opportunity to share how we do it as well.
I think we are done.
We're in there. Reaching out
Thank
here.
you very much. But if there are any questions, too late.
Yeah, thanks.